All right, so we're live. Thank you, Sandy, for sharing. Okay, so Victoria and Willie, we're going to check on 905B7. Yeah, 905B and C, just because of the doing business issue.
Mm-hmm.
Take it away. It's all yours.
All right, Willie, are you out there? I think you might be.
I'm here. Good morning, everyone.
There. Good morning, Willie. All right, Willie and I met last week to discuss this, and we talked with our respective analysts. And Willie also, I believe, Willie, you touched base with Jamie. Is that right?
Correct.
Yep. Okay. The result of our discussion was that 905B is fine as it is. It appears that it is a new insertion in the existing statute, and we definitely have, we definitely would like to see 905C stay where it is. So we are fine with B as it's written and C as it's written.
Okay.
And
Good.
Willie?
Yeah, we just wanted to make sure. I know that these
Mhm.
issues have a real impact on what you do. So
Willie, would you like to add?
Nothing from me. Quick and simple.
all right. Well, that's straightforward. Good. Yeah, because I think from my perspective, what those do is they working together, they leave the issue up to Department of Revenue to make their own standards and rules. So okay, good.
Okay.
So where are we then? 905B and C. 908. Did we get 3 to 10 already?
I think we made it to 10.
10.
I have all the marks that of us going through. I have an LC mark here.
Yeah. All right, cool.
Yeah, I had us getting through 912, and we were going to look at 905, and then there were some ORS statutes that we were going to look at, and then we're on to 12, or on to 12, and then pick up the miscellaneous ORS statutes.
Yeah, I think the one I had a note about 63,810. Hold on. Oh, what's going on here? 63. Yeah, so 63,810 is just the taxation of limited liability companies and members, and basically says, and I think we can just make a note. It basically just says that, we follow federal treatment for tax purposes. My recommendation would be that we just flag this for LC and let LC do what they will with it.
And Valerie, where do I want to mark that?
I think a note after, maybe a couple carriage returns after that consensus adopt 912.
Yeah. I'll do one of the LC ones.
Yeah, with the asterisks.
My computer says type.
Because it doesn't strike me as a particularly substantive provision for LLC governance, but I think it's really intended to be a cross-reference.
What was the, I'm sorry, Valerie, you want me to flag it?
Can we have a couple carriage returns before those asterisks?
Sure.
Just say, 63.810 needs to be incorporated somewhere.
Okay, so Valerie, you're saying that's not in reference to 912. It's just, it needs to be in there somewhere.
Right, and that's why I was saying I want a couple carriage returns, not just one, because I want it to be
great.
set off from 912.
Got it.
Yeah, perfect.
And I'll put space between the other one.
Yeah, and you might also put in a note about 63.074 because it's just basically, it says you can't have an illegal purpose.
Okay.
So those were the two notes that I had about sort of ancillary statutes before we move on to 10. Anybody else have anything different?
So 63074 was one where I think we had decided to not adopt it in toto, but rather to like cut certain portions and keep certain portions. So, but what I was understanding, what we were just saying was saying 63074 needs to be adopted in its entirety. So maybe we need something more nuanced.
Yeah.
I thought what we were saying was leave it to ledge council to decide what.
Well, yeah, but for example, like, we had decided that the first sentence of 074 sub 2, we had decided to drop it. So like, that's not, I mean, it's one thing to leave to legislative council the placement of it, but I think the substantive decision whether to, this is, the language is part of our bill is up to us. And, I mean, we can do whatever we want, right? We
Yeah, I
can change
mean, I
our
think-
decisions, but
Cody, I think what we want to do is say, also this section as not inconsistent with what's above. Right?
sure.
Because that second, let's see, the first sentence of the second is basically the one subject to the laws of the state, the rules and regulations of regulatory board of profession, and the standards of conduct, if any, a limited liability company may render professional service in this state. So that's a, and I think it didn't fit in the general purpose sections that we were talking about before, which is why I think we decided to axe it.
Yeah, and I think Valerie was going to check with DOJ charitable activities section about the first sentence of subsection 1 of
Mhm.
074.
Yeah, and I didn't do that, but we can do that as part of our follow-up after we have everything together. So Sandy?
Yeah.
After that 074, put a paren, start paren. As not inconsistent with above. Or if not inconsistent with above. Maybe if not inconsistent with above would be better.
Okay.
And then close paren at the end. Okay. Article 10. Okay, so we have a prefatory note. I think, Article 10, let's come back to the definitions. I think we had a couple of markups as we were going through on the definitions. I'll make a note that we're coming back. So let's go down to the substantive provisions of 10. Because I think to the extent that we adopted the terms, the substantive provisions, the terms are okay. So that's 1002. Yeah. I don't actually have any changes. Did we go over these sections?
I'm not sure we did. I think all of part 1,
Yeah.
because they related to all the other transactions described throughout Article 10, we decided to discuss the transactions themselves
Okay.
and make back references to part one as necessary. So I'm not sure we did discuss any of these sections
So let's start,
specifically.
let's start with section 2 and then do section 1 last. Does that sound reasonable? I think that's consistent with my understanding.
1021.
Yeah. Yeah, 1021. Okay. And I don't actually have any changes on 1021. Yeah, consensus. 1022. I have a note on 1022 A6 about material terms and conditions. Does anybody else have that note?
I had, that was something we discussed and decided to adopt Rolka as is.
Okay,
I had the same as Cody.
all right. Any other changes on 1022? No. 1023, approval of merger. I have lots of handwritten notes around this one, but no actual changes.
Yeah, here the discussion largely centered around whether we want to keep the requirement, the default requirement that it must be approved by all members. And after some back and forth, we decided to keep it.
Okay. 1024. So for 1024, I have us getting rid of sub D.
Yep.
I have in my notes that we discussed, we initially decided deleting it, and then we were to keep it. We decided to actually keep it.
My notes are we deleted it, and I put the commentary that it was a discussion about the ORS that I cited, if I got that one right.
Yeah,
I'm fine if we delete it, but I have different notes.
yeah, that's the same note that I have, Sandy. Anybody else on this one? Okay. 1025.
These are the changes I made based on what I recall the conversation to be.
Let's see, statement of merger, plan of merger. Yes. I don't have, so are we, where is that coming from? Is that coming from 6304-494?
Yes, 63-4941B is what I have in my notes.
Okay, yeah, that makes sense. So the plan of merger change is actually coming from the current ORS. Merger, integration, address. Yeah, that looks good to me. Thank you for doing that, Mosin. Application for registration. Yep.
Valerie, could we go back to 1023 really quick?
Yep.
And it's more just kind of a practice point. I'm curious if anybody really ever sees operating agreements to provide for their address approval of a merger in it. I often see.
It's very frequently, at least in the ones that I've seen, it's very frequently in the voting thresholds.
Cliff, what was the question? I'm sorry, I didn't understand.
Just in operating agreements, I don't know if many people are drafting them with voting thresholds for mergers. I think to your point, Valerie, I often see them with, in protective provisions where it would be required, but I don't know that would get to what the statute is requiring. So the only thing I would, and I'm not necessarily suggesting a change, but something for consideration could be just having the threshold for approval of a merger be the threshold for approving an amendment to the OA, just because frankly, if they can amend the OA, they could amend the OA to change or incorporate a threshold for approving a merger. Does that make sense?
What is the threshold for approving an amendment to the OA? Is it not unanimity?
It is in the default rule, but then most operating agreements generally have a lower threshold. right? And to the extent they're not addressing approval of a merger, you could at least go to the amendment provision, because again, it'd be a different way of getting to the same result.
Yeah. So that would A, be a poorly written OA under this new statute, because it didn't anticipate that possibility. But B, remember, there will be fiduciary duties that limit someone's ability to kind of go around that provision, but the unanimity requirement for mergers by amending the OA to require something less.
Yeah, it feels like there might be a good faith type argument in that scenario, but relatedly, the concern I have is the default rule today is majority, and we're going to now change that for everybody over time if they don't change their operating agreement during whatever interim window there is. And I feel like that's a substantive change we're making.
Yeah, so we had a extensive discussion about whether to do that or not, and it dealt in part with the interplay between the absence of appraisal rights in the revised statute. Because you don't have appraisal rights, the default is you have to approve a merger, and that's where we landed on as a committee, that we want to keep the unanimity requirement in the revised statute. But if others want to open that discussion up, we can open it up again.
I don't know
Let's
that we
move on.
necessarily need to rehash that. Yeah, I mean, I think that is something we should flag for the bar and drafters though going forward. So perhaps Sandy. Yeah, so we have that in there already, so.
And these are the notes I took from our discussion. If you'd like me to add something, I'm happy.
No, I think that's fine. I mean, I think what we're gonna have to do is we're gonna, when we're preparing CLE materials to educate the bar is go through and pick up on these areas where we have additional commentary. Okay, 1025. So these changes are to make it consistent with the requirements of the current 63-494, and I think that they're good edits. Anybody have any questions or concerns about them? One thing that I did have flagged in my notes, Sandy, if you'll scroll down to F, that or I have a note that we wanted to flag that for legislative council, whether it made sense to have it be and, or if or would be better.
So flag that for legislative council specific.
Yeah,
Do you want me to do one of our ones on the bottom?
I think that's probably, yeah. So just say LC flagging this or issue in F1. Okay. Okay, 1026. I have a note that we had intended to add 63-497 sub 1.
Sorry, where?
Sub 1H.
I think that's it right there.
Yeah, if prior to a merger. Yeah. Is that the only change we've got? Again, I've got a lot of sort of handwritten notes and here, but that's the only actual change that I have reflected.
I inserted this comment just because we had discussed this,
1I.
that we don't need to add this part of ORS because it's covered already in a different part of the statute.
Right, the ABN stuff. And for those not in their statutes, it's just, the section just says the registration of an assumed business name of a business entity under ORS chapter 648 shall not be affected by the merger. So we've already covered that, I think, when we talked about the ABN stuff.
Yeah, except Sandy, the reference should be to 1026A6 instead of 6A.
I can
Sorry
change,
about that.
no problem.
Great. Good job. Okay. Why does it say no interest exchange?
Well, there was some discussion about, well, there was some discussion. I'd advocate for the position that we shouldn't have this part, but I think the group decided that we should include interest exchanges as a possible transaction.
Oh, so that was an
but-
editorial statement, Mohsen?
No, I didn't add that. I didn't add that. So I don't know where that came from. I know there was discussion of that, but I don't think it was the prevailing committee view.
Okay.
I was taking notes. It was going through there because someone had said it very loudly, I think, or not. It's in a very strong argument. So
So just add a bracket there, Sandy, and we'll move on.
I got rid of it.
Bracket.
Bracket on. Oh yes, thank you.
Oh, no,
Wait,
before the word part,
wait, where? I'm sorry.
one line down. Before the word part.
Yeah.
Not that line.
I-
The
So above 1031, yep, right there.
Right there on the left margin.
I'm sorry. I see what's going on now. There you go.
okay, scrolling down. Paste.
So I circulate this comment with some of the others who were presenting on the other sections in this article. But it's just I can't remember what the comment said. Let's see.
Yeah, I have the same, I have a note about a transitional rule. A similar transitional rule is unnecessary. Yeah.
One issue that I don't know if we punted to legislative council or just punted to discuss later is in part C. We need to, the idea here is to have some kind of effective date that we identify. And we haven't done that yet.
Right. So Sandy, underneath Mohsen's comment, do the asterisk LC question regarding effective date and transition into full effectiveness, full implementation or something like that.
I know from my previous projects, there's a couple ways of doing that. You could declare an emergency if you want it faster or not. And there's sort of strategic decisions around that.
Okay.
So but we can.
Yeah, I don't think there's an emergency.
There's a lot of bills. I would say there's a lot of bills where emergencies are declared. There is no emergency. It's just for experience.
We're having an LLC emergency. Good times. Okay. Maybe get rid of that extra I.
Yep.
Okay, 1032. I have a post-it on here where I wrote stick with Rolka. Right. Yeah, I see, Susan, I see your comment. That makes sense. Okay, so 1032, plan of interest exchange. I think we had a lot of discussion about this, but I think that we ultimately concluded that we were sticking with it. Anyone else have something different? No? Okay. Scrolling on, 1033. Similarly.
Yeah, I didn't have we change anything.
I didn't either. And then on 1034, I just have a note saying that it's intended to, I mean, a lot of these provisions parallel Rolka, the 1024 section, merger section. And then I have us deleting D on 1034, which I think was intended to parallel our deletion of that.
Yeah, that,
section.
if that's the case that we deleted D on mergers, then we should do it here too.
Yeah, that's what I have in my notes.
Yeah,
I didn't
And
make
that's
that
gonna-
change because I didn't have the initial change in my notes either, but if that's what we
Yeah,
agreed to, we should change it here.
that's what I've got in my notes. Does anybody have anything different? Okay.
I
All right.
have omitted in my notes,
You have what?
and just so the word omitted.
Oh,
for
okay,
some-
good, good. So I'm not hallucinating.
Now it's smart, consistent with how we've done deletions.
Okay, 1035. Yeah, so this is intended to parallel 494 again.
Right.
Well, 494, so it's the same changes, so I think I'm okay with that. Anyone have anything different? Oh, I have a note, yeah, about 494.1. Yeah, and that's been added in. 1036, effective interest exchange. Similarly, that or language. Does anybody have a note about or at the end of 1036? What is that? Wait, where are we, Cindy?
Oh, sorry. We're in 1036.
Okay, so 1036 D. Oh, that's that same language that got added in before. Okay, so we're gonna see that, I think, through the other parallel provisions, because these provisions sort of march together. Okay, 1030, oh, 1041. So 1041, I have a big X mark through C. Does anybody else have that? Okay, so let's axe C there.
Valerie, I had also in my notes that we were going to add a comment that we're not adding rights that don't exist today.
Okay,
Please don't ask me to explain that.
yeah, I have a comment, but my handwriting is illegible, so I'm glad that yours is better. And it's on an orange Post-it. Okay, so yeah, so James, would you mind restating that?
Yeah, the intent is not to add rights that don't exist today. Yep.
Okay, great. Okay, 1042, plan of conversion. I don't have any changes, lots of notes, but no changes. 1043. Ten 44. Again, 1044. I have a note in here. Something about Michael delete D in parens. Is there a D?
There's no D.
I don't know what that note. Michael, do you know what I was talking about?
So not to,
Valerie, I'm just looking this over. I
Okay.
don't recall what that means.
at the risk of confusing us all, I have a note on the issue of abandonment in C.
Okay.
And my note says that we restored it for all.
Oh, no.
Oh,
That's-
no.
That's my recollection, is that we got through my parts and then we got here and decided, okay, we actually like the idea of abandonment. And we checked with Secretary of State and they said it would be no problem to accept this kind of statement. And then we decided to keep it for all. I have it in all caps in both of my sections.
I've been wondering why we were getting rid of it because it exists today and I don't know, it seems useful, but I didn't want
Oh,
to.
all right. So let's go back to,
Is
What
Jamie on? Does she recall the conversation?
Yes, I'm
There she
here.
is. Hi there.
And hello, and I do have a note that we just needed to, we're gonna have to create a new form for it. So it looks like
Oh.
that's my note anyway.
All right, so back to 1024.
Restore all the abandonments, is that the
Yeah,
result?
basically.
That's okay.
1024 and 1034.
Better we do it now.
Feel
Mhm.
vindicated.
Yes, you should. You tried to save us from my there you are, there we are, yeah.
So I'm basically I'm just undoing this.
Yeah. And then we have to change the comment.
Yeah. That's okay. Okay.
And then 1034.
I was, yeah,
I think there was another comment that probably needed to be deleted,
in 1034.
wherever we just were.
1024.
1024. Yeah.
Yeah, because there
you're right,
was a
Roberta.
comment saying we did not intend to create rights, and I think we do intend to create rights. There we
That
go,
was-
that
that
one,
was-
commentary.
So get rid of this.
Yes.
Oh, thank you.
Okay.
And 1034. Okay. All right, those are struck through now.
Is that a thing? Okay. 10. Where are we? 10, yeah, 1044, right?
Yeah.
Wait,
Because
Yeah.
this we were
there's the
talking.
abandonment. Okay. Okay, so we're okay with this now? Let me fix my notes. 1040. Okay. 1045 statement of conversion. Well, so I
Here-
have a note that you were
yeah.
you were drafting something.
Yeah, I circulated to the folks that were leading discussions in this section. Basically, we need to make conforming changes to each of the 35, 45, 55 that include this additional subparts B3. This one already has a B3, so this would probably be B4 or 5, somewhere in here that has this additional language. I'll put it into the chat, but it's just the conforming language that's in 1025 and 1025 and 1035.
Yeah, that makes sense because I think that's statutory, right?
Oh, so where,
Yeah, it comes from 63, 476, sub 1B for conversion.
So, Sandy, what we need is a note to legislative council here.
okay.
Oh,
After-
we've added this language to 1025 and 1035, so I just think we should add it here
Agreed.
rather than having legislative council add it.
We can, or we could. just
Agreed.
add it to it.
Most, where would it make the most sense to put it?
Yeah, I'm just scanning this now to figure that out. Sandy, give me a second, please. Who was the one who covered conversions?
I'm looking at this maybe between current B and C. I think that would be consistent with the way we handled it
So
previously.
would it be B6 or would it be a whole?
New
I
C.
I think it would be a new C.
Yeah, I agree with that.
Yeah, this was Jeff and Michael.
Oh.
Well, Michael, because I think Jeff had left us by that point.
So Mohsen, it makes sense for me to put it after B5.
I defer to Michael if.
That's
I
where I
think
would put it.
James said too.
That's where I'd put it, Sandy. Yeah, and
Sorry. I don't know why.
And this language needs to be tailored because it's just the language from the merger provisions, but now it needs to be applied to conversions.
but you can mimic the language very closely.
Wait,
But yeah,
you want it to be red, right?
yeah, I'm doing right now.
I wonder if it makes sense to have it in C, because C says, well, C said something along the lines of, or something else, because what we're talking about is a statement in lieu of, right? I don't quite remember what C said, but it struck me that that might be a good place for it.
So this
Yeah.
is actually a new C, correct?
Yeah, correct.
Okay,
Yeah, I think you're right, Roberta. Now that I'm
yeah, because it says in
back and
addition.
forth,
Mhm.
so
But
maybe
then
it
it-
is.
but I think we want to keep it consistent with the others, and by
Yeah.
making it part of B, it means the plan of merger is part of the statement, or excuse me, the plan of conversion is part of the statement of conversion. And I think we're contemplating that it would be its own separate deliverable. In other words, you still file your statement of conversion, and then separately you can have a plan of merger. I keep saying merger, I mean conversion.
But
Yeah, so I think it should be I think it should be B6 for the reasons James said.
Yeah, I've toggled back and forth and I agree with that now. Sorry.
Just
So-
that will make it consistent with how we've drafted the merger and issue or interest exchange provisions.
Exactly. So it's a sub 6.
That's how it currently reads.
And rather than merger, you would say conversion.
And for what it's worth, Sandy, you can ignore this for now. For Mohsen and Michael, I have a note also that we added application for registration, which I guess would be because you're now a new, well, I don't remember what that is. Does anyone remember what that is?
Why don't we let Sandy finish doing this and we'll talk about that.
So basically, every time I see the word merger, I'm changing it to
Yep.
convert.
In this instance.
Yeah, of course. Thank you.
James,
I figured it
but I think,
out.
yeah, I think it's instead of statement of qualification,
Yep.
we're talking about, we don't have that. We have an application for registration. So there was a conforming change in
5.
1025 that we could incorporate, or we could just.
So it looks like C talks about a statement of conversion, not a plan of conversion. I mean, is that significant?
The statement of conversion is what gets filed with the Secretary of State.
Okay,
But
Which is different than the plan.
to Roberta's point, if we're allowing a plan of conversion that would be a private document potentially, don't we, I mean, we're kind of creating a new thing that doesn't exist in ROLCA. Do we want to allow that to have other provisions too?
I don't understand the question.
Should C be revised to say a statement of conversion and a plan of conversion may contain any other provision?
Yeah, I have that as a change that we need to make in C. Yeah.
I mean, under current law, it's called articles of conversion. So the statement of conversion is just the counterpart under ROLCA. I mean, under current law, you have articles of conversion and a plan of conversion. Those concepts both. We're just bringing in this subset in
Right,
what is now 6
James's point is
that
just
talks
in
about where the
C.
plan of conversion must be
Yeah, so
either
James's point is,
in the statement of conversion or on file with the office.
so Michael,
the
James's
entity.
point is that in C, as we have it right here, do we need to add and or a plan of conversion?
I don't think we do. 1042B already expressly says that. It says a plan of conversion may contain any other provision not prohibited by law.
Yeah, I think I agree with Cody now. I think that we can just keep C as is.
Yeah.
I think C is fine.
Yep, and Sandy, you have an extra space after conversion in 6.
Yeah, I see it. Thanks.
Good. Okay, moving on. Anything else here?
If we're deleting spaces, then I'm going to go a step further. We have an and at the end of 4 and a period at the end of 5. We need to move that
Right.
and to the end of 5, right?
Yeah.
And make a period at the end. Yeah, it's already there at the end of 6.
Say again, sorry.
So Sandy, at the top of that screen where you've got number 4 in black, you want to delete that and at the end.
Yep.
And then at the end of 5, take out the period and put a semicolon followed by the word and.
Oh, did I put a regular colon? Yeah. There you go.
And then in that same line, I think we need to change statement of qualification to
Application for registration.
thank you, application for registration with a cross-reference to ORS.
Oops, hold on.
And it needs to be statement of qualification is what's struck.
Oh, so, thank you. It's replaced with
Application for registration. Open parentheses, ORS 67.603, close parentheses.
okay. Thank you. Does that look right?
Mhm.
One more change, Sandy. In 6A, it says surviving entity in the middle, and I think it needs to be converted entity.
Oh, right.
And that change again happens in B.
So it's converted entity
Exactly.
and also in B. Yeah, I see it.
Does anyone know offhand whether constituent entity makes sense here?
Oh, which is right here. In B.
I think that's fine. Because constituent here
is
means related, right?
So is the converted entity, or, I mean, are there other entities involved?
Right, there is no other entity involved, maybe constituent entity, and it's a constituent is not a defined term in this article.
I think here it just means related. I don't have a problem with it.
I think Roka's using the term converted entity. In this
No,
context.
the converted entity is not what you're talking. Oh,
What is the pre-converted entity called? The converting
yeah, that's
entity.
fair.
Yeah, I think it should be converting entity,
I think that's good.
Any
which is a defined term here in article
Yeah,
in
Right.
that makes sense.
1001.
Yeah, so go ahead and change that to converting.
So Sandy, instead of any constituent entity, it would be the converting entity.
Yeah.
The converting entity.
Yeah, I was thinking about it
Yes.
more in terms of, if there are other relationships that would have to be noticed there, but that would be included in shareholders, I guess. The converting entity. Well, we already have entity there.
Oh, is it double? Yep, there it is. And I'll get rid of that space.
We're like the space police here.
I'm
Yeah.
on.
Space Force?
I have this hypersensitivity to it because I'm told you're not supposed to put 2 spaces after a period now.
True.
So
I
which-
know, and I can't stop myself because that's the way I learned how to
it's like
type.
automatic, right? For those who learn to type on typewriters.
They were teaching that all the way up to when I was learning how to type and even further, I think. So it's, yeah.
Oh, well, okay, so that looks good. Any other changes to that? Okay, 1046, effective conversion. Do have some notes on this one. So if you scroll down to B, I have a note that says that between B and whatever new section, we were going to plug in 63479G language and 1H.
I think I have the 1H language. It's the same language that was in the merger and interest exchange provisions.
Yeah.
Here it is from the merger provision. They just need to be tacked on to D2.
E2.
D as in dog 2.
Well, I have a new C and a new D. So do we want to do it there? Conversion becomes effective. Is that the 479G?
Actually, this is the, I think it's the language from, I don't have the OR statutory site.
Well, because I have 2 additions to this section. I've got after B, new C, where we plugged in, because I've got 63479G and 63479H. Or I guess they're both one G and 1H. And I think that we've made those changes before. So what I would suggest that instead of us trying to wordsmith this, we just tell legislative council that we want to insert that.
So do it after, at the end of this one.
Yeah, does anybody have any concerns about that?
I think it's probably the way to do it if we've already done it.
Yeah, so it's a consistent with above.
Yeah.
Comma. Insert language from
Oh,
ORS 63479, 1 in parens, G and H in parens. And I put an ampersand between G and H.
got it.
Does that look okay to everybody? Okay. But that's the only change I've got to this section.
I have a question, and this maybe, I'm not sure exactly if it relates more to 1045 or where, but one of the things that ORS says is that for if a LLC organized under Oregon law is converted to a foreign LLC, then, or it says you may convert to a foreign LLC if the converted business entity submits an application for filing to the Secretary of State to transact business in this state. And sort of, the requirement of registration with the Oregon Secretary of State for any foreign entity. And I was wondering if we want to make sure to add that to our version of ROLCA, or if, and if so, it makes me wonder, given especially with domestication and also for the interest exchange, do we need to add similar language to the other provisions of Article 10?
So the question is, if you have a foreign LLC that wants to do the things that we're talking about in these sections in the context of Oregon, do they need to register first? Is that what you're asking?
No, it's like, as I understand the current ORS, it's if you want to convert to a foreign entity and still be transacting business in Oregon, you need to register. as a foreign business doing business in Oregon. And so that's like, it's in 63,470, which is, talking about how you do conversion. I would think it would, where it would fit here in the ROLCA would be like under 1045, and it's similar iterations for the other parts of Article 5. I don't know if the Secretary of State has some other generalized statute which requires foreign businesses to register to do business, if that's under Chapter 58 or whatever. But it seems to me, at least as to conversions, I didn't readily see a explicit similar language for merger under Oregon 63. But it seems to me that we want to have somewhere in there the requirement that foreign entities doing business in Oregon be registered to do business here.
I think it's in 902. You already have to register if you're a foreign entity. I think this is the one you're citing is a helpful way of saying it a second time to remind people. It wouldn't surprise me if the Secretary of State's forms end up having a box check, either I'm no longer doing business in this state, check, or enclosed is my statement of registration.
Yeah, I think that's.
Which isn't to say I oppose those changes. I would be fine with what Cody is suggesting too. I thought I would mention that I do think.
No, that's great. I don't mean to create duplication. And 902 talks about a foreign LLC. And I would assume then, I guess, if you are converting to a foreign corporation, then our corporate, Chapter 60 would have something to say about how you need to register. So I guess it's a moot point then. So never mind. Good point. Thanks, James.
Okay. All right. So with that, let's go to 1051, domestication. And I don't have any changes on 1051. Or 1052. Actually, I don't think I've got flipping through this. Oh, I do have a change on 1055. So anybody have anything before 1055?
Did we make changes in 1046B or around B? I had notes that we were going to plug in similar things from the merger section.
Yes, that's what we just put there.
Oh, we just did. Okay, sorry.
Yeah, no, rather than having us go through the process of typing it out, I think we can just plug it in. Okay, so domestication, anything before 1055?
No, I know.
On 1055, I have us striking the word time.
Oh, yeah. Where is that? Because
F1, 1055 F1.
Yeah. So it's just the date. So just start and time.
Correct.
Does anyone remember whether we did that in the prior one? I had a circle around it with a question mark, so I didn't speak.
I think we removed time in every one of these provisions. So
I
if
think
we did,
Yeah, I think wherever we've found it, we've removed the time requirement, but maybe put a note here to Legislative Council, Sandy, just saying, in case we missed a time, please delete.
Yeah, I was going to suggest the same thing, Valerie, that they just need to search and destroy throughout the statute.
Did we do that because there's a statute that says the effective time of any of these transactions is X, or what was the rationale behind it?
I think they don't, there's not a way, well, first of all, it's not something that Secretary of State collects now as far as information. And there's not, I don't think there's a way to really do that.
But don't we need an effective time for transactions to determine liability, for example?
Well, I think to the extent that there is anything in the common law now, I don't think we're adding a time requirement.
Well, Cliff's point is, I think we can specify the time today. And I hear your question, Cliff. I feel like there's a way that we got there through a different section. I'm scrolling now because it does seem like there needs to be a way to specify a time.
I just remembered quite a bit of discussion on this point, but I thought it was a much earlier statute.
It was, I mean, I think it was, we were talking about some of the earlier filing statutes, right?
The effective time of the filing, yeah. And
Yeah,
isn't
but-
that what we're talking about here?
Yeah, I have us, my notes have us deleting all references to the time of something from the statute throughout the whole act.
Yeah, because Secretary of State doesn't timestamp documents. I still think in the documents that we file, we can specify the date and time.
It's in 207.
207, James?
Yes. You can put a time in the record.
Right. Which, as I read it, isn't that consistent with current law
I think so.
in 63?
But I don't think that there is a, let's see, notification is effective in the state.
So is the question whether the time is based on when the filing happened with the Secretary of State, or whether it's based on something that was put in the document that creates the domestication or the conversion or whatever? Because if the Secretary of State doesn't track, then we shouldn't have that, but the company should have the ability to put a time in if they want to have an effective time.
Like midnight at 12/31/2022
but-
or something
right.
like that.
But what we're talking about here is we're talking about F1 says the date and time provided by the organic law of the domesticated entity, which is the default time, right? So, I mean, you can specify a time saying when it's effective that's later than the default time.
So if we don't have time in there, is it just going to be as of, somebody said 12:01? Is that what Kevin said, I think?
Or two, that's what 207 sub
Yeah.
4. Just wanted to make sure we have a time.
Yeah, no, that's a good catch, Cliff.
Yep.
And a good find, James. Okay, moving on. Okay, 506 or 1056. What are the numbers there?
So
A note about adding the 479, 497 language again. Here,
can I ask a question? I'm sorry, going back to effective time.
yeah, sure.
Did we make I'm sorry, Sandy, can you scroll up to 207 and show whether we made a change?
Yeah, I'm happy to.
We did make
Because-
some changes, but I think we left the part that talks about 1201.
Okay, because right now 207 in my PDF anyway says it's effective at the time of its filing, which is presumably what we were trying to get around because our
Yeah.
Secretary of State's office
We
doesn't.
we
require
carved
that.
up 207.
Yeah. I've
Okay,
got a bunch
if
of-
people remember it that way, don't waste
Yeah,
the time. I'm sorry.
here's 207.
Take a look there.
Yeah,
All right.
there's 12:01.
There's enough tinkering there. I'm sure we did it.
Okay, one more question on that. I think it's 1055F where we were before. So it says, we took out date and time, and then it also says, and when the statement is effective. So
The latter, it should be or.
it should be
Right.
or, yeah, that's what I thought. Or, yeah, something like that. But that was in Rolka, so
I think it should be or,
I think it should be too.
because it's the latter of X. Does that look weird to anybody else?
It should be or, the later of
We
date
flagged this for LC somewhere else just today.
or, so that they're at,
Oh, yeah, we did, didn't we?
Yeah, I wonder if maybe a
no,
comment is
not
better.
there, not there, Sandy,
Oh.
but down at one, at the end of one, it says and that should say or.
Oh, that's right. We flagged it
Oh, there
earlier.
we
in
go.
the-
Yeah.
Yeah.
My only recommendation would be that Legislative Council go find them all and make sure they're consistent.
So yes, can you highlight that in yellow or something, please, Sandy? The word and.
Uh-huh.
And then add a second asterisk comment.
Mhm.
LC, please find all.
Let me just shout. All. How do we
and
describe this?
Slash or make sure consistent.
Okay, and slash or. Oh.
Yeah. But maybe highlight that and or thing with yellow just so they can tie it to the.
Yeah.
Do that.
The
Okay. So we need to go back at this point. Oh, anything on 1056? I don't have any changes on 1056. Oh, other than on 1056, we need to add in another legislative council note.
Yeah.
And it just relates to that add language 63, 479, and 97, 497.
Wait, sorry, 479.
479 and 497 as above. Okay, back to 1001.
Here we are.
Yeah. So the 1001 is just the definition, and I think David and I looked at this early on. The 1001 is just the can you go back to the top of the section, please, Sandy? Yeah. So this is just the definition section. And I think that there wasn't anything that left out to me, except that with respect to entity, I have a note that, yeah, so entity that it doesn't exactly, let's see. Yeah, this list doesn't exactly line up with where we are currently. Like, for example, I don't think it has PCs on it.
I thought I have a note here saying that we had decided to adopt a comment saying that business corporation includes both those under chapter 60 as well as professional corporations under chapter 58.
Yeah, and I don't even know that we need to go do, I mean, we should do something to flag the issue. But I don't know if it's add a comment or if it's have legislative council make the list consistent with the current list of Oregon entities. People feel strongly one way or the other.
I think I would turn it over to legislative council to make it consistent, just to, you know, put it on them to do it.
Yeah.
Um,
It's sort of
I just
my
have reference to ORS 63.467 to that definition.
Yeah, so maybe between 11 and 11A, can you put a carriage return, Sandy, please? And then asterisk. And then just LC make consistent with 63.467. Make this list consistent with, I mean, we just need to make sure that we're speaking the same language here.
Entities, correct?
Mhm. Okay. We do have so in 14 below, we have, the definition of governor too. Right, which is sort of the catch-all, and that also needs to be consistent with the list. Yeah, so 14 and then 15, but 15 is where it has the list of.
Yeah.
Yeah, I have 16 as well tagged and 18 tagged,
Mhm. Yeah, so
29 tagged.
Sandy, maybe, I don't know, how do we want to do this?
Maybe copy that comment and put it
Oh yeah, that's a good idea.
and paste it back in.
Yeah,
wherever
under
it
all of
needs
these
to
sections.
be. Yeah, just to make it easier for them to find it rather than saying, refer back. Yeah.
You want to put it above 15, is that right?
Well, put it after 15. I mean, between 15 and 15, no, between 15 and 15A.
15, yeah.
Sort of like we did above. Yeah, good. And then 16.
Sorry, 16. I see it. There it is.
18.
But it's not entities, it's just gets consistent, right? I'm deleting the word entities.
Yeah.
And I just have to do that above one more time. Sorry about that. Because it's an entities before, I don't want to miss.
It's fine, Sandy. I understand what you're saying.
And then we're doing it. Actually, this one. That's correct. What's the next one?
18. $19.
Do we need it for 19?
I don't think we need it for 19.
First holder. Oh, you're right. Sorry. 29 is what I meant.
29.
Yeah.
Do we need it for 31 too?
Yeah, looks like. And then on the only other comment I have on these definitions is for 30, did we do something with protected agreements?
I don't have any notes to that effect.
Can you
Either.
Okay.
What does that relate to? Is that the,
Yeah, that's what I'm wondering.
is that the idea that, oh, I'm sorry, Valerie.
Sandy, can you do a search, please, for protected agreement?
I'm just wondering if that goes to the point that I think Mosen was making earlier, that we're changing the default rules to unanimity for voting for mergers and stuff. I wonder if that's what that relates to.
Not agreement, Sandy. Agreement, singular. Okay, so what this is it's, yeah.
Oh, so that is what it is.
Yeah, so like covenants in a loan document, for example. Okay,
Well,
so
it
we
says-
left it in there.
There's a comment in the document that I'll just read real quick on page 189. If a protected agreement has provisions that apply if an entity merges, those provisions will apply if the entity enters into an interest exchange, conversion, or domestication, even though the agreement does not mention those other types of transactions.
Yeah, that makes sense to me. I think it made sense as we went through too, because we left the definition.
Yeah, I agree.
Okay, so thank you, Sandy. You can X out of that. Okay. Anything else on the definitions? Okay. Relation, so 1002. That looks fine to me. Wait, let's make sure, Sandy, before you scroll, it looks fine to everybody else. Anybody else have any changes to 1002?
When it's talking about business organization in B, does that implicate anything that we have just done with respect to the definitions of adding things to the list?
I don't think so. Because the definition of, hold on, okay. Domesticating.
I think B may be targeting, just reading the notes, the comments on B, looks like it may be targeting something that we don't have, to my knowledge, under Oregon law. Any takeover provisions?
Mm-hmm. Does its inclusion here create problems down the road that create some additional right? Because I think it basically just says that we're not impairing anything else that may exist within the code. I don't read it as creating an additional right, but I just want to make sure nobody else does.
I think I agree with you, Valerie. I haven't studied it, obviously, but it seems to be a placeholder that would apply if we have other regulations that apply,
Yeah.
but it'll be meaningless if not.
I mean, we could insert a comment to that effect if that would be helpful. Does anybody think that that's helpful or necessary? Because I think it would be fine to do if people do. So maybe Sandy, do a character turn where you've got the cursor now and just say comment. It is not the committee's intent to create any rights that do not exist with this section.
That do not currently exist.
Yeah. Does that look good? Okay. 1003, required notice. So this is a section that I think implicates something we don't really have under Oregon law, which is to say charitable LLCs, because you can have a charitable single member LLC, and I know IRS is examining multi-member nonprofit LLCs. Again, I don't think this creates additional rights. But just says that, if there are restrictions, then those restrictions should continue to apply.
I think the question here is under B, whether we want to make people go to the court or the attorney general. I would assume, circuit court, I don't know, Marion County or maybe just, a circuit court without specifying which one rather than the attorney general, but I don't know.
Well, yeah, Attorney General Charitable Activities Division may have an opinion about this, though. So can we just flag that for Legislative Council to? Legislative Council make consistent with current venue rules. And then highlight the bracketed language, please, Sandy. Yeah. But beyond that, I don't know that there's much for us to do there. And then 1004 is basically sort of the same idea that, there are many different ways to get there.
Valerie, do you want me to get rid of this legislative note? Because this is actually just from the text.
Yeah, I think so.
Oh.
I mean, we've already given Sean a copy of this
Mhm.
document pre markup, so he'll have all of the original commentary.
Exactly.
Yeah.
I'm just gonna, when we're done, I'm gonna go through and remove all this, anything that's superfluous before we give it to Sean. That's my thought.
Okay. Yeah, I mean, I think we've done a pretty good job of taking out that stuff as we've been going through those.
There's still a few lingering.
Yeah, no, that makes sense. Okay, 1004, any thoughts? (1005) 106, I have a 1006. I've got a note saying no default appraisal rates. But I think that that's essentially what the section says. Say if you've agreed to this, then you get it. If you haven't agreed to it, then you can fight about it, basically. And I don't think that we have any excluded entities or transactions. But, do we want to flag 1007 for Legislative Council to just say, we don't think this applies, but let us know.
No, the comment mentions as examples of things you might put here, nonprofits and banking entities.
Yeah, so maybe leave in that comment and then just ask Sean if he thinks it's necessary to include.
So we're basically just flagging this entire section 1007 4LC to take a look at.
I mean, that would be my thought. Does anybody feel strongly that we should do something else there?
No.
Okay.
Maybe refer LC to the comment that James was mentioning.
Yeah, Sandy, I would not delete this comment.
Yeah, good call. I'm gonna leave it.
And maybe insert the specific note that they should look at. No, No, I think that that comment captures it. So I think that's good. All right, anything else in Article 10? Do we want to take a break before we get to Article 11? Quick break.
Nods.
Is that, I'm sorry, Sandy, do you say yes or no?
Saw some folks nodding.
Okay, let's
Yes.
take a quick break. Let's take a quick break then and come back. So Article 11 is very short.
It is.
So Sandy, would you mind? Yeah.
And a lot of 11, we'll have to see what we actually want to put in from 11. You'll, give me one second, let me just get to it. There it is.
Yep.
Okay.
Yeah, and so 101 or 1101. I have a comment that something about, well, I don't know what my comment says, but I have need circled and the word desire substituted. I don't know if that's what anybody else has.
I have it underlined, that's all I have. So we must have talked about it.
I mean, I think the idea of, I have a note saying keep concept.
I recall the discussion be about whether when we have adopted other uniform acts, we use this language need or not. And I have to assume that we decided that we did use this language because no one seems to have any notes to say we actually want to change it to something else.
There's actually language similar to this in Oregon's version of the Uniform Partnership Act, ORS 67. I think it's
Does it use the word
basically
desire?
verbatim.
Yeah, I had us adopting this as is and, adding a comment to indicate that where we have departed from ROLCA, then that would essentially be given effect, but I don't even know if that comment's necessary.
Yeah, I don't think, I mean, I think that's probably what mine says, maybe.
I think we've made that, yeah, Cody, I think we've made that pretty clear. And I think that's one thing that that's more of less a comment I think we need to have in the document, but just something that we need to be aware of to discuss when we present the bill. Because I think there's always some skepticism of just full uniform laws in Oregon, but we've certainly spent a lot of time making sure this is not a wholesale uniform law.
This nitpicking, but my notes indicate that we, or at least I did, I got rid of the word uniform and then capitalized act.
Oh.
So I just wonder, what the group thinks about whether a judge would look at this section and what a judge would think about it, or if a litigant would raise it.
I think Michael's point is well taken that, there's similar language, and that's where I think my note about desire comes in, because I think in other uniform acts, we have similar verbiage.
Yeah. I mean, 67.800 is the one I was referring to. Roberta, I think it's a good point. I think if you're dealing with litigants presenting a case to a judge and there is maybe persuasive precedent from other states that have adopted ROLCA, then I think you present those along with this section to reflect the intent of the legislature. So,
yeah. So maybe a comment just saying, comment, it's the work group's intent that, this is similar to what we did with 67-800.
Yeah. And we have been very careful to make sure that we include things from ORS that seem to be important rights that we're preserving. So it's not just we're not creating rights, but we're preserving rights that were important in Oregon law.
I want to make sure I get that citation right, Valerie. 67-800.
Correct.
And this kind of language is I mean, this is in every uniform act, you know, whether it's the Uniform Arbitration Act, Uniform Commercial Code, the Uniform Trust Act, you know, and from a litigator's perspective, the reality is that you do cite case law from other jurisdictions, and you talk about, you know, if you like the case law, you cite the variant of this language saying, well, we should follow those other cases, keep it uniform. If you don't like it, your opponent cites this, and then you try to say, well, but there's a good reason why all those other courts are wrong, or what have you.
Right. So maybe a 67,800 comma et al. Or et cetera.
Yeah, I mean, this is, I think it really is in every uniform act.
Yeah.
Yeah, no, I understand. As maybe like as an example of other uniform, I mean, I don't
even know what we needed to comment. I mean, it's just, I think this is so, to me at least, from again, the litigators, but this is so standard in every uniform act that in fact, the proposition here generally goes without saying, like courts are familiar with this rule.
Right. I just, if they have standard language as between the different uniform acts that they're using in Oregon, I just think the language should be standardized.
No, they don't. They don't. It's the short answer. The same concept is expressed in a variety. I don't know why the National Conference on Uniform State Laws doesn't have a boilerplate that goes into every uniform act, but it doesn't.
Yeah. So I think that's fine. And then 1102 electronic signatures.
I have a question. I think, Valerie, you had noted we need to comply with the Oregon E-Sign Act or something to that effect.
Yep.
And the Oregon Trust Code has a provision that says, for whatever reason, it doesn't seem to mention the E-Sign Act, but does mention the Oregon law. And it says the legal effect, and I should preface this by saying the trust code is in ORS 130. And it says the legal effect, validity, or enforceability of electronic records or electronic signatures under ORS Chapter 130 and of contracts formed or performed with the use of such records or signatures are governed by ORS 84.001 to 061, which is our Oregon Act.
Right.
And I don't know whether you thought it was important to have similar language here or not.
Yeah, I mean, I don't think it hurts. So maybe just a note to LC, just relating it to chapter 84.001 at SEC.
We're confirming it to 8401. I mean, sorry, not confirm. We are just making
referencing, like a cross reference.
Do we know how the act actually does limit and modify the electronic signatures in Global and National Commerce Act? Does anybody have any idea?
So my belief is that e-sign applies where a state doesn't have a state law that gives validity to electronic signatures. And so my interpretation of this language is to say, here's the law with respect to LLCs, at least, that deals that is intended to supersede the E-Sign Act, so the E-Sign Act doesn't have to apply.
Yeah, and we have an Electronic Signatures Act in Oregon. So Sandy, after 884.001, put a comma. And then ET space SEQ.
Okay.
Okay, savings clause. I have no changes. Except that, you know, legislative council needs to figure out
effective date.
Effective date, yeah.
I'm gonna flag that because I just don't want to, is that okay? Just they don't.
They have a note that says default 1/1 year after session, but you know, again, that's going to be whatever they decide. And then I have us actually striking the severability clause. Is that in anybody else's notes?
Yeah, I have that we wanted to use the language from 174.040.
Yep. Yeah, so don't delete the heading there, Sandy, just the text. You can delete that legislative note. And then a note to legislative council there.
What do we want to put in the note?
So substitute 174.040 language.
Sorry, 174.040.
Yes, sir.
Okay.
Okay. And then like the rest of this stuff, I think is just, we just punt this to legislative council if they need it.
Agreed. I'm gonna put a note again, just to make sure.
Mhm. Yeah, and I would just say 1105 and 1106. Great.
Just a
Anything
quick
else?
note on severability, Valerie.
Yep.
There's other entity statutes that was just again picking up Oregon's version of UPA.
Mhm.
67805 does have a somewhat similar severability provision in there. So it might be appropriate to have LC look at that and decide whether to keep Rolka's severability provision.
Okay, so what was the statutory citation there, Michael?
67805.
Yeah, so maybe instead of substitute 174.040, say LC, please include language similar to and then ORS. Well, you already have ORS there.
And
So for what it's worth, 1104 of Volca looks to be very similar to chapter 60, 60.971. I wonder if they're the same sentence.
So Sandy, after ORS,
Yep.
Space 60.971.
That's right. I think it may already be there.
Yep, comma 67805, comma, and then after 040 do a comma and then etc. And that way he can just figure out what language he wants. Anything else for the good of the order?
Just a couple of things. I know that when I logged on before we started recording, there was chatter about the dentist provision, ORS 63.960. Did we decide we don't need to add that?
Reached out, heard back. The person who I spoke to was their point of contact for Legislative Affairs Association, didn't know about that statute. So she was reaching out to colleagues. Haven't heard back yet, but I'll check back with her.
Yeah, so
Okay.
if we hear back, then we can, and they want changes or something, we can always reach back out.
Okay, so our default is just to drop it.
I think so, because our general decision was to go with what Rolka says. Unless there was some compelling policy reason otherwise, but they may come back and say, yes, we want to include it, in which case we'll just talk to Sean about that.
I'll check.
Okay. And then
I
the
don't
other
know.
one I was going to mention is 63.990, which is the penalty for signing a false document. I think we need to add that to Article 11 here.
Let's see, 63,990.
Yeah, you know how Oregon likes to have the criminal
yeah.
provision at the end of every chapter.
Yeah.
Yeah, that seems reasonable.
That's an L-
Jamie, it looks like it's a Secretary of State provision, so I just want to make sure you're okay with us putting this here. Is Jamie still with us?
Yes, sorry, I couldn't unmute, but yeah, I think that's fine.
Okay.
So an LC note here, Valerie.
Yeah. include 67,990 penalty provision.
So 60, it was 63,990.
No, 67.
Thank you.
Oh, well, it should be 63, right?
That's what I thought.
It is
Yeah.
63.
It is 63.
Sorry, I was looking at the, I think it's a partnership one. Yeah, partnership. Yeah, same language though.
Okay.
They also have 63,992, which I think we've generally tried to include, but we should also probably flag here for Sean as well.
Yeah, I think if you do a word search for 63.992, I think you'll find that we talked about it in conjunction with section 305, 306,
Yeah.
somewhere around there.
But let's, after penalty provision, Sandy?
Yeah.
Let's add a comma and just, double check that we've, substantively included all of 992 that we need to. Because that is a clear policy.
Yeah, that policy remained that the policy remains consistent with ORS 992.
Well, and just ensure that ORS 63,992 substantive provisions are adequately incorporated.
And just so I'm clear, it seems like there may be some overlap with section 205, which is
Yeah.
liability for inaccurate information filed in filed record.
Okay, so should we include a cross-reference to that for Sean, just to make it easier for him?
Yep.
Um,
Don't want anything inconsistent.
yeah, no, so after incorporated period, and just say, addressed in 205, so we just need to be consistent. Is that a fair comment? Okay, good. Anything else? Well, if you're like me, things will occur to you after you sign off the call. So, feel free to email Sandy, email me, and then to the extent that stuff needs to be discussed, we'll circulate it to the group. But I just wanted to thank you guys so much. It's been a huge trek and a huge push to get to this point, and you are all amazing. So I really appreciate all your hard work.
I'm in awe of your commitment to this group, everyone, for the level of the quality of expertise we have here. Thank you on behalf of the commission. I know for the state, there's a lot of work left, but I think this is a really, really good product.
Yeah, good, big milestone here, and we're finishing early today, so even better. All right.
Down.
We would be remiss if we didn't thank our fearless leader,
Oh.
John DiLorenzo. Just kidding,
Mm.
sarcasm.
No,
Valerie,
John-
you did a great job shepherding us through, in particular, keeping us on task. So thank you for that.
Hey.
Oh, well, thank you all very much. And, we're going to get a lot of heavy work out of John going forward, because this is really where he excels in dealing with all the politicians. So, but yeah, thank you. And thank you all so much. I mean, this has really been quite a heavy lift, and I think we've got a great work product. So look forward to updates coming out, but for now, we're off your schedule. So enjoy your summer.
Valerie, will you
Thank
hang
you all
on
so much.
for about 5 minutes?
Pardon?
You hang on with me for about 5 minutes.
Yep. All right. Thank you. Good
Well,
luck. Have a great